Welcome, everyone. My name is Ben Gioretta. I'm the chair of the London branch of the Chartered Institute of Arbitrators. Now, as is now traditional with these Zoom webinars, we have to just wait a little bit while all the participants join. For some reason, the technology is designed so that people can only trickle in rather than all appearing at once, but they are joining now. I'm just watching the participant counter. So there's a message here from Paul Rose to say good evening to you, Maxey. Paul Rose, of course, invited you to give this speech last year, but unfortunately we had to postpone it. Well, the numbers are still coming in, but I think we may have enough to start the introduction. And I will say a few words now, and I'm sure by the time I finish speaking, before we get on to the important stuff, we will have everyone in. So welcome everyone to the 2021 keynote speech of the London branch of the Chartered Institute of Arbitrators. But normally we would give this speech in some rather more impressive surroundings of the Oxford and Cambridge Club, but this year, for obvious reasons, we are doing it all online. It gives me great pleasure, however, to introduce our speaker. Our speaker is just as eminent as in the past. In fact, she would have been our eminent speaker last year, as I've already mentioned, but unfortunately we had to postpone it. So it gives me great pleasure to introduce to you Professor Maxi Scherer, who is the Professor of Law at Queen Mary University London, the School of International Arbitration there, where she holds the chair for international arbitration, dispute resolution, and energy law. She's also a special counsel at Wilmer, Hale in London, and she's admitted to the bar in Paris and is a solicitor in England. She has extensive experience with arbitral practice, both in civil and common law systems, with a particular focus on the energy sector. She's represented clients, provided expert opinions, and sat as arbitrator in more than 100 commercial and investor state arbitrations under a whole range of different rules and under a broad variety of governing laws and seats. She's been regularly ranked by Chambers Global, Who's Who Legal, the Legal 500, etc., as a leading arbitration practitioner. And she is repeatedly identified amongst the top global elite thought leaders, and in 2021, one of the most in-demand arbitrators in Europe. Now, the rest of her CV is set out in the flyer for this speech, of course, as a sign of how eminent she is. It's a very, very long CV, so I'll leave it to you to read the rest of it. Her speech today is on the proper law of the arbitration agreement, a comparative law perspective. And she tells me that her speech will be around about half an hour. And then afterwards, we will have a Q&A session. If people have questions, please could they put them into the Q&A box on Zoom rather than the chat, so that we all know where the questions are. And with that, I'll hand over to Maxey.
Thank you very much, Ben, and very warm welcome also for my part. It's a pleasure to see so many attendees in the list. Many thanks to the organizers, the Chartered Institute of Arbitrators, London branch, for inviting me for this keynote 2021, and in particular its chair, Ben Gioretta. It's a great pleasure and honor for me to be delivering this keynote speech today. Before I start, I have one housekeeping matter. Unfortunately, this is not the Cambridge and Oxford Club, as you can see. So unfortunately, less glamorous surroundings on my side. And it's also not my usual setting, office setting. So I cross my fingers that we don't have a problem with the internet. But if that is the case, I would just ask Ben to give me a little heads up. The topic of my talk, the proper law of the arbitration agreement, a comparative law perspective, was of course triggered by the recent UK Supreme Court decision in Enka versus Chubb earlier this year. However, what I will not do today is give you a detailed analysis and discussion of the decision in Enka. I'm sure many of you will have participated in events discussing the Enka discussion. So what I will do instead is use Enka, the Enka decision, as a stepping stone for a broader comparative law analysis and looking at the proper law of the arbitration agreement, how it is dealt with in jurisdictions around the world. And it is actually rather surprising that this fundamental question of what is the law governing the arbitration agreement has no clear, uniform, and harmonized solution when you look at it globally. Of course, we do have Article 5.1a of the New York Convention, when it comes to the recognition and enforcement of arbitral awards, which provides in essence that the law is governed, the arbitration agreement is governed by the law chosen by the parties, and in the absence by the law of the seat. I'm not quoting here, I'm paraphrasing Article 5.1a of the New York Convention. However, the interpretation and the application of that provision around the world is such that there is no uniform and harmonized approach, as I will be able to show you in the 30 or so minutes that I have. So what I will do, first of all, in the first section, is set my stepping stone, and that is the Enka decision. So I will briefly remind everyone of the findings in Enka versus Chubb. And then in a second step, I will, and maybe more importantly, discuss what is the proper law of the arbitration agreement from a comparative perspective. I will present my research in form of a world map. And then in the third section, I will draw some conclusions from that research, comparative law research. So first of all, very briefly, a summary of the Enka decision, which is 150 pages long, so I'll make it very short. The factual background is simple. There was a fire in a power plant in Russia that occurred in 2016, allegedly the fault of the subcontractor doing some works in the power plant, Enka. And the contract between Enka, the subcontractor, and the main contractor, that contract had an arbitration agreement, and it also had a provision for a seat in London. It did not Chubb. The court asking for, I see Ben appearing.
So we just lost, well, I just lost you for a second there, I'm afraid.
I do apologize. I'll start back on where I was.
Yes, please. You were describing the fire at the power plant and the arbitration clause.
I do apologize. I hope it won't happen again. So the fire occurred and Chubb filed proceedings in Moscow before the courts in Moscow, and Enka resisted those proceedings in Moscow, and at the same time filed proceedings in England before the English High Court, requesting an anti-suit injunction and a declaration that the arbitration agreement was valid and that actually the claims fell under that arbitration agreement. So it was in that context that the question of the validity of the arbitration agreement and the governing law appeared. And the question was really one, if you applied English law, it was fairly straightforward that the claims, which I understand to be tort claims, fell within the arbitration agreement, whereas if one applied Russian law, it was rather clear that these claims, or at least there was a risk that these claims would not fall within would fall outside the arbitration agreement. So here the English Court of Appeal decided that the question of the arbitration agreement was governed by English law. And it did so on the basis of the choice of the parties of the seat in England, and it interpreted that as an implied choice of law in favor of the English law as the seat of the arbitration. The decision then came to the Supreme Court, and the Supreme Court, in a 3-2 majority, upheld the decision of the Court of Appeal. I'm going to present you with the rationale of the majority. The majority found, like the Court of Appeal, that the arbitration agreement was governed by English law, but on a very different basis. The rationale for coming to English law was different. It did not find that there was an implied choice of law based on the law of the seat. Rather, it decided there was no choice of law at all, neither explicit nor implicit governing the arbitration agreement, and therefore one would apply the closest connection test, and that closest connection test led to the application of the law of the seat. So same outcome, English law, but from a different, on a different path, a different basis compared to the Court of Appeal. Importantly, when deciding the Enka case and giving the result I just gave you, the court also outlined a number of broader directions regarding the law governing the arbitration agreement. And it is those that have sparked quite a bit of discussion and debate. I'll try to summarize them fairly simply by looking at 3 hypotheses. There are 2 simple ones and 1 complicated one. The first one is actually the simplest hypothesis, and that is if the parties have specifically and expressly chosen a law governing the arbitration agreement, well, then you apply that law. Everyone agrees with that. The second hypothesis is one where the parties have not chosen any law whatsoever, not regarding the contract and not regarding the arbitration agreement specifically. And here, as I've just said, the Supreme Court decided that the fallback was the closest connection, the seat of the arbitration. So that is a fairly simple hypothesis as well. Now comes the third hypothesis, and that is the one that is most complicated and, unfortunately, also the most common when it comes to international commercial contracts. And that is the parties have chosen arbitration, the parties have chosen the seat of the arbitration, the parties have made a choice of law regarding the contract, but they have not made a specific choice regarding the arbitration agreement. And it's in that hypothesis, that is most common, and the Supreme Court here has given the following directions. In that hypothesis, as a matter of principle, the law governing the contract as a whole, the lex contractus, applies also to the arbitration agreement. That is the presumption. And that presumption is not displaced in favor of the seat by the mere fact that the parties have chosen a seat elsewhere. So let me give you an example. If the contract is governed by English law, the arbitration agreement in it will also be governed by English law, and that even if the parties have chosen a seat in New York or Sao Paulo or Paris or elsewhere. That is the principle, the direction in principle set out by Enka. Now, however, there are two exceptions. The first, potential exceptions. And these potential exceptions means that there might be situations where this presumption in favor of the lex contractus is actually displaced in favor of the law of the seat. Now, what are those two potential exceptions? The first exception, potential exception, is if the lex contractors would invalidate the arbitration agreement. That is what is typically called the principle the principle of validation. So if the lex contractors would actually lead to invalidate the arbitration agreement, the presumption is displaced in favor of the law of the seat. The second exception outlined by the Supreme Court is as follows, and I'm going to quote it here. This exception applies if any provision of the law of the seat indicates that where an arbitration is subject to that law, the arbitration will also be treated as governed by that country's law. Now that's fairly dense. Let's try to unpack that. And the easiest way is to actually give an example to illustrate what it means and what happens here. The example I would take is that the parties have entered into a contract that is governed by English law, and they have chosen a seat for the arbitration in Sweden. Now, according to the principle in Enka, the arbitration agreement is governed by English law, but here the exception applies because Swedish law, the law of the seat, indicates, in particular in its section 48 of the Swedish Arbitration Act, that whenever Swedish law is chosen as a seat, it should also govern the arbitration agreement. So if the law of the seat wants to be applied to the arbitration agreement, that also means that it applies, and so the presumption in favor of the lex contractus is displaced. Now, as I said, I'm not going to go into the details of the dissent, but this is in very brief summary the directions given by the Supreme Court in Enka. Now, if you allow me one comment on the Enka decision. Now, whether you agree or disagree with the conceptual solution provided by the UK Supreme Court, what one can say, I would submit, is that it is a fairly complicated solution because it has this principle and exceptions in the most common hypothesis in commercial contracts. If you think about a concrete example where the parties have entered into a contract where the contract is governed, say, by the laws of Bahrain, and they've also chosen ICC arbitration with a seat in Switzerland. And if an English judge were to be asked to determine the law governing that arbitration agreement, what an English judge would need to do is to, first of all, determine as a matter of principle that Bahraini law, as the law governing the contract, in principle applies also to the arbitration agreement. However, first exception, the judge would also need to determine the content of Bahraini law and ascertain whether there might be a risk that Bahraini law invalidates the arbitration agreement. And if so, rather apply Swiss law as the law of the seat. The English judge would also, second exception, determine the content of Swiss law in order to determine whether Swiss law, just like Swedish law in my prior example, does not contain a specific provision that also means that the arbitration agreement is governed by the law of the seat, and again displace the presumption towards the law of the seat. So it is before even getting to determining the proper law of the arbitration agreement, the judge already has to ascertain two foreign laws, Bahraini law and Swiss law, in my example, before even getting to the proper law of the arbitration. So that seems to me a fairly complicated intellectual process, probably one that is conceptually correct, but from a practical point of view, rather complicated. And if you think about parties and their counsel trying in advance to ascertain whether an arbitration agreement is valid, and therefore having to determine the law governing the arbitration agreement, they have equally to make all these complicated assessments. Now, one way, of course, of getting around these complications is to put in the arbitration agreement an express provision, an express choice that says this arbitration agreement is governed by law X. But as we all know, that rarely happens. Now, let me now move to my second section, which is the comparative research. And it was indeed triggered, my interest in doing this comparative research was triggered by the Enka decision and by a specific part of the Enka decision. There is a section which is entitled The International Perspective. It is at paragraph 55 and following, for those of you who have the Enka decision in front of you. And here the UK Supreme Court analyzed and referred to a number of international authorities and solutions in other jurisdictions. And it noted that the lex contractus approach, its preferred approach, was supported by international commentators. It was generally followed in ICC arbitration, and that it was adopted in a number of civil law and common law jurisdictions. And it specifically cited Singapore, India, Pakistan, Germany, Austria, and maybe with a little question mark, Hong Kong, Australia, and Switzerland. Now, without spelling it out expressly, the Supreme Court seemed to suggest that international authority is in favor of the lex contractus approach, that this would be the prevailing view internationally. And it was that assumption that triggered my interest. And it was that assumption that I wanted to test in my research. So I have come up with this map, which is I'm now going to share with you. If Ben could just let me know if that is now visible for everyone on the screen.
Yes, it is.
Excellent. So before we look at this map together and I give you a little bit of more information about the assumptions and the methodology used, I would like to start by thanking a number of my colleagues who have been extremely helpful in putting this together. Without their help, I would not have been able to do all this research, too many to name, but the whole exercise has been led by my colleague, Dr. Ole Jansen, and I would like to specifically thank him for that. I should also mention that in putting together this map, we've used a number of resources, and in particular, the Dealer's Guide to Arbitration Places, or called GAP, which is a comparative guide for over 60 jurisdictions around the world. So it has proven useful in this type of exercise. But even with those most wonderful resources and helpers, it is of course not an easy task. It's not a box ticking exercise. It requires quite a bit of analysis and interpretation to get to these to these colors, which I will explain to you in a second. So if any of you disagrees with the analysis, please do let me know. I would be very happy to hear your comments online or offline. Now, on the methodology, the factual hypothesis that is underlying this map is what I called earlier the most common hypothesis in international commercial arbitration, i.e., where the parties expressly chose the law governing the contract and the seat of the arbitration, but did not make a specific choice regarding the law governing the arbitration agreement. And for that factual scenario, we assessed whether the courts in over 80 jurisdictions would rather apply the lex contractus or rather apply the law of the seat or apply another solution. Now, there are quite a few countries still in gray. Those are countries where we couldn't access information or where our research was inconclusive because there was diverging case law or diverging interpretation of statutory provisions. Again, if you have information on those countries, please do send me an email or get in touch to let me know, and I'd be very delighted to discuss this with you. Now, the four colors that are on the map are the 80 jurisdictions that we have found a conclusive research and have color-coded. So the ones in blue are the ones regarding that would, in the hypothesis that I outlined, favor the law of the seat. So you see here, for instance, you have Mexico, you have Argentina and Chile. In the Americas, you have Egypt and Nigeria. On the African continent, you have the big blue of China and Russia. And then further east, you have Indonesia and New Zealand. And then coming back to Europe, you can see Poland, you can see Sweden, and if you look closely, you can see Scotland, which was a little bit more complicated because this particular application only allowed you to color political countries. So we had to actually do this manually. So the jurisdiction of Scotland can have its own legal solution. So I do hope my Scottish friends appreciate that. So all of these blue countries in the hypothetical that I outlined would apply the law of the seat. To the contrary, the green countries would apply the lex contractus, the law applicable to the main contract. This is the US and Canada, it's Paraguay, Senegal, Algeria, just to mention a few, and then Iran, Pakistan, India, Australia, of course, and probably you can't see Singapore, and in Italy, in Europe, Italy, Germany, Austria, and of course England and Wales. Now, there are two more colors on the map, the orange ones and the yellow ones, and these are countries that apply a different solution than the seat or a lex contractus approach. Let me start with the orange ones. These are the countries that apply the so-called validation principle, and there are in alphabetical order the Netherlands, Peru, Portugal, Spain, and Switzerland. In Switzerland, actually, this principle is even codified in section 178(2) of the Swiss Private International Law Act. And it provides, and I'm going to quote here, that an arbitration agreement is valid if it conforms either to the law chosen by the parties or the law governing the subject matter of the dispute, in particular the main contract, or Swiss law. So you have basically three avenues: law chosen by the parties, law of the main contract, Swiss law, and whichever favors the validity of the arbitration agreement comes to apply. So it's a pro-arbitration approach, and one that gives a maximum effect to the arbitration agreement. The underlying rationale, of course, being that the parties could not have chosen a law specifically to the arbitration agreement if it invalidates the arbitration agreement, and they must have made a mistake. So this is the orange approach. And now, last but not least, the yellow approach, which is what one would call the a-national approach, or sometimes also called French approach, because it has been championed and invented by the French courts. But it is also applied, as you can see here on the map, by a number of African countries, and this is in particular Mauritius, Benin, Togo, and the entirety of countries of the West African OHADA. This is the Organisation pour l'harmonisation en Afrique du droit des affaires, so it's the Organization for Harmonization of Corporate Law in Africa. So what is this a-national solution? It means that rather than determining the governing law and applying a particular national law, the French solution is to apply a so-called international principle that only looks at the common intent and will of the parties. So the arbitration agreement is seen as an autonomous contract within the contract it is contained in, and that arbitration agreement, its existence and its validity is determined regarding only the content and will of the parties as part of this international, so-called international principle. I'm going to come back on these on this approach a little bit later. Now, let me, having given you this broad overview of the world map, let me now come to my point, which leads to the analysis, what conclusions can we draw from this map? And here I have two comments. The first is, if you look at the map, it seems to me that this comparative law research actually shows that there is no majority at the international level for the lex contractus approach, contrary to what seems to have been suggested by the UK Supreme Court in Enka. If anything, if you look at the numbers, the sheer numbers of jurisdictions, a majority of them, 51% here, in my analysis, in my world map, 51% would actually favor the law of the seat, compared to only 34 in favor of the lex contractus. However, it seems to me that it is important to go beyond a purely arithmetic and quantitative analysis and actually also do a somewhat more qualitative analysis. And that is, if you look at the major arbitration jurisdictions around the world, they seem to be divided amongst which approach to take for the proper law governing the arbitration agreement. If one takes, for instance, the latest ICC statistics, the most popular seats in ICC arbitration are, in this order, the UK, France, Switzerland, and the US. And I should say, it probably shouldn't say UK, it does say UK, it should probably say England, but I'm not going to dwell on that point. But none of these four jurisdictions actually applies, interestingly, the law of the seat. Two of them, England and the US, apply the lex contractus approach, and the other two have what I call these alternative solutions, the a-national approach and the validation principles, the French and the Swiss approach, respectively. So I think overall, the most accurate way of presenting the data here is that there is no clear preference for any given of the four approaches when you look at this internationally and globally. Now, let me stop my screen share just so that I can I'll come back to some more statistics, but I'll leave you without the world map for the time being, and come to my second remark and second sort of analysis of this comparative law research. And that is what to make of these alternative solutions, as I called them, what to make of the validation principle and what to make of the a-national approach. Let me start with the a-national approach, the French approach, as I may also call it. The advantage of this solution is very clearly that it's very simple. You basically don't have to bother with determining the governing law. All of the questions that Enka had to deal with, you just skip them. And you immediately apply these international principles and the simple application of what was the common intent or will of the parties. In my view, there are, however, two major problems with this approach. The first, in my view, it leads to quite important uncertainty as to the validity of the arbitration agreement. And that is because it's unclear beyond the statement that you should look at the common will and intent of the party, what happens if that common will or intent of the parties is unclear. For instance, can you look at extrinsic evidence when determining the will of the parties? What viewpoint do you take? Do you take the viewpoint of an objective and informed observer? At what moment in time do you place yourself to make the assessment of the common intent? Is it at the time of the conclusion of the arbitration agreement, or is it ex post with the hindsight of today? All of these are questions that you would usually try to find answers in the principles of contract interpretation, in the principle of contract construction under the governing law. So if you don't have a governing law regarding the arbitration agreement, then you do not find easy answers to all of these questions. And hence, my concern regarding the uncertainty. The second concern I have, and this is more a conceptual concern, is I wonder whether it is not somewhat conceptually dishonest to call this approach an approach of international principles, because these principles really have been shaped by, first and foremost, the French courts. So whether they are international principles, I wonder, and whether this is not a very good packaging, and this is somewhat provocative on my part, it is not a very good packaging for actually applying the lex fori approach, the French approach, to the law governing the arbitration agreement. Now, I won't dwell on this point further because I'm actually a French advocate. I'm a member of the Paris bar, and if I continue, I will probably get disbarred as we speak. So I'd rather turn now to the other alternative solution, and as I call it, alternative solution, and that is the Swiss solution, or the validation principle, which in my view is more promising. I can already tell you that. It is a very sound and well-established principle of interpretation in many countries, that if the parties have chosen to include a certain provision in the contract, it is unlikely that they want the law governing the contract to invalidate that particular provision. And that sound principle of interpretation applies to arbitration too. As I said earlier, the Enka decision specifically also includes in the very complicated test an exception for this validation principle, in the sense that the presumption of the law, the lex contractus, is displaced in favor of the seat if the former, the lex contractus, invalidates the arbitration agreement. The main problem with the validation principle is that it arguably cannot provide a solution with regard to all questions relating to the arbitration agreement. The validity, substantive and formal validity of the arbitration agreement is one question, but there are other questions regarding the arbitration agreement, its interpretation, its scope, that all require to determine the law governing the arbitration agreement. A certain Gary Bourne in his treatise actually has identified no less than 13 sub-questions regarding the arbitration agreement that could potentially be governed by different laws. So I'll refer you to that. But for the validity of the arbitration agreement, formal and substantive, the validation principle works well in that it allows us to choose from the relevant laws, law of the seat, law of the lex contractus, potentially even the lex fori, the one that leads towards the validity of the arbitration agreement. But for the other issues, it's less clear. Take, for instance, the scope question that was underlying the Enka decision, whether or not a tort claim falls within or without the arbitration agreement. It is not very clear why would one want to favor a broad scope as opposed to a smaller, a narrower scope. It's not a matter of validity of the arbitration agreement, but it's rather one of construction of the parties' intent regarding the scope of the arbitration agreement. And this is something that, in my view, the minority or dissent in the Enka decision actually noted quite appropriately. And this is at paragraph 198 of the decision, for your reference. Lord Sales and Burroughs actually noted, and again, I'm quoting here, the validation principle rests on the rational assumption that parties would prefer to have an agreement upheld than not. But if it is correct that there is no dispute about the validity of the arbitration in this case, the Enka case, the validation principle is not a reason here to favoring English law over Russian law as the proper law of the arbitration agreement. And I think that is a valid point, that when it comes to questions, for instance, of scope, the validation principle is maybe of little use to determine the governing law. Now, another part of the research in this context that I would like to share with you is that it appears that the majority of cases of case law that deal with questions of determining the proper law of the arbitration agreement actually deal with questions of validity, formal validity or substantive validity of the arbitration agreement. Let me go back to my slides so that I can share this with you. And I would just ask Ben again to confirm that you have it all in front of you.
Yes, it's here.
Excellent. So what we have done here is we have looked at 200 published decisions, court decisions that is, from around the world that deal with the question of the law governing the arbitration agreement. And we've asked ourselves, what was the underlying issue that actually triggered the question of the governing law? And here are the results. In those 200 cases, 51%, over 51%, dealt with the substantive validity of the arbitration agreement. A small number, 7%, dealt with the formal validity, and then 18, 16, and 13% respectively with the scope of the arbitration agreement, the arbitrability, the extension to third parties, and a small number with only the interpretation of arbitration agreements. Now, let me just clear with the methodology. These are randomly selected decisions from about 30 jurisdictions around the world. It does not include any decisions by arbitral tribunals. And it's by no means a comprehensive research. There are, of course, more decisions out there, but they're from this data set of 200 randomly selected decisions. It appears that almost 60% actually deal with questions of validity, substantive validity or formal validity, when it comes to determining the law governing the arbitration agreement. So what that also means is that in a majority of cases where the question of the governing law comes up, the validation principle actually allows you to find a meaningful solution. Now, I hope you have this in mind, because I'm going to stop my screen share again so that I can come back to the main screen and come to my final remark and conclusion. I want to make sure we have extra time and enough time for comments and questions. And my final remark and conclusion, and this is going back to what I said in the introduction, is that it is quite extraordinary that for those fundamental questions of the proper law of the arbitration agreement, there is so much uncertainty. Uncertainty within a jurisdiction. If you think about Enka, you have different approaches at the level of the Court of Appeal, the majority of the Supreme Court, and you have the dissenting minority, and each of them very forcefully argues different approaches regarding the proper law of the arbitration agreement. But you also have uncertainty on a global level, because the comparative research has shown that there isn't any one approach that has a prevailing view overall globally, and in particular in the major arbitration jurisdictions. So different approaches coexist, and that even though we have the provision mentioned in the introduction of Article 5.1a of the New York Convention. Now, one way out of this uncertainty could be to apply Article 5.1a of the New York Convention, not only in the context of recognition and enforcement of arbitral awards, but generally when it comes to determining the proper law of the arbitration agreement. And in a fairly literal reading, I admit, of Article 5.1a of the New York Convention say that either the parties have expressly chosen the law governing the arbitration agreement, this arbitration agreement is governed by law X, and if they haven't done so, used a fallback solution, that is in Article 5.1a, which is the law of the seat. Now, this solution is simple, it is pragmatic, it might not have the conceptual beauty of the solution that were outlined by the Supreme Court, UK Supreme Court in Enka, but it would certainly be a solution that allows to evacuate and eliminate some of the uncertainties that exist currently. So let me stop here, and I'm happy to elaborate on this solution, but as I said, I'd be very interested to hear other people's comments and questions, so I will stop here, and thank you all for your patience and your attention.
Thank you very much, Maxi. Now in this very bloodless and strange world we're living in, normally at this point I would invite a round of applause from the audience. There are some comments and thanks in the chat box, but can I say on behalf of all the attendees, thank you very much indeed for such a clear and lucid explanation of what is really quite a complicated topic. And you criticize the Supreme Court for suggesting that there was a majority view. I think the problem with the Supreme Court is that they didn't have the benefit of your speech and your very helpful map. If they had that, then they would have perhaps taken a different view of it. There are a few questions in the Q&A box. Could I start up, before coming to them, however, could I ask a question from myself? You started off the speech by noting there's a harmonized solution. And of course, at the end of the speech, you gave a very sensible, possible solution, harmonized solution that countries could adopt. I just wondered, from your knowledge of the history of international arbitration, why there hasn't been a harmonized solution to date, and why the solution that you have recommended in Article 5.1a wasn't adopted, wasn't expanded and to cover all these issues at an early stage of the development of arbitration.
Thank you, Ben. It's an excellent question. My sense is that everyone agrees on its face with the solution in Article 5.1a of the New York Convention. You either choose the law or you apply as a fallback deceit. Where the divergence comes from is how parties can choose the law governing the arbitration agreement. Some, and I am part of those, might say you have to have an express choice regarding the law governing the arbitration agreement to apply this part of the provision of Article 5.1a. Others might say, when choosing the law governing the contract as a whole, the parties have also chosen the law governing the arbitration agreement. And therefore, within this harmonized provision of 5.1a, you still have a possibility for diverging outcomes. So I don't think the New York Convention historically had the possibility to solve this. What historically might, or what might solve the uncertainty is the very literal reading that I suggested. And again, I can see a number of downsides also to this reading, but at least it is simple, and at least it's very clear. Any client that asks you, what is the law of governing this arbitration agreement? Is it a valid arbitration agreement? You can give a yes or no answer, and you don't have to go through a number of exceptions and potentially ascertaining foreign laws with all the complications that we know that that might entail.
Yes, well, that's very true. It is a much more straightforward answer. Shall we have a look at some of the questions from the audience now? And shall we start off with, well, we'll come back to Marina's question about Enka, perhaps, because that's a bit specific. But James Canchi's question about the ICC rules compared to the LCIA rules, that does the Enka case expose a defect in the ICC rules, namely an absence of a default choice of law of the arbitration agreement, a defect not found in the LCIA rules or the LMAA terms?
I'm not sure I would call it a defect for the ICC rules. But what is true is that there is a specific provision in the LCIA rules. This is the 2014 and now 2020 LCIA rules, so it's in the old and the new version. In Article 16.4, that specifically provides that the law of the seat applies unless the parties have chosen otherwise. Now, there are two ways of looking at this. One way of looking at this is that is a provision that departs from Enka in the sense that it actually has a little bit of a different wording. It says, unless the parties have agreed in writing regarding I'm sure about the in writing part. I'm paraphrasing the rest regarding if they have chosen a law or rules of law regarding the application of the arbitration agreement. So if there's a specific agreement in writing regarding the applicable law. Now, this wording is slightly different from, of course, what is in Enka. So one could argue it is a departure from Inca. So whenever you have an LCIA arbitration, you don't even get to Enka. The other view of looking at this is you also now have in the new LCIA rules, the 2020 LCIA rules, a provision that says in Article 16.5 that the rules themselves need to be interpreted according to English law. And therefore, English law means, for interpretation of contract principles of English law. And this is precisely what the Supreme Court applied in Enka. So 16.4 of the LCIA rules actually would therefore be falling back to what the Enka decision is in the UK Supreme Court. So I'm not sure there is a clear solution to that. I'm happy to hear James' views about this, but I see at least these two potential readings of Article 16.4 of the LCIA rules. The ICC rules don't have a provision, and therefore you would just apply the law governing wherever the seat of the arbitration is. Not the law of the seat of the arbitration, but the rule regarding the determination of the proper law of the seat of the arbitration.
There's a risk, isn't there, by adding these various provisions to the rules, you're just adding another layer of complexity onto it, making it all more complicated. There's another question here about Enka, which is the Supreme Court has put invalidity as an exception to the lex contractus. So can't we just say that the test applied by the Supreme Court in Enka is the same as the validation principle? I mean, aren't we talking about the same thing in effect?
I wish I could give you a clear yes or no answer to this one. My reading of Enka, I'm happy to be corrected on this, is that the Supreme Court actually said it depends on the likelihood of invalidation, the likelihood of risk of invalidation. There might be cases where it's a very clear risk of invalidation, and therefore we apply the validation principle as displacing the presumption in favor of the lex contractus. And there are other cases where we're less sure about the invalidation, and therefore we do not displace the main presumption in favor of the lex contractus. I think that is less clear than the Swiss solution, which says you have three outcomes to come to one result, and that's the validity of the arbitration agreement. You can take either part as long as you get a valid arbitration agreement. Maybe it comes to the same result, but it seems much more complicated to get there.
Yes, all these solutions do appear to be complicated, don't they? Let me just, there's a question from Queen of Baltag here saying, will the Enka decision have an immediate impact on the choice of seat? You think parties will choose their seat in light of the Enka decision? And perhaps one we could take at the same time the earlier question, which is, has English law been fixed as a result of Enka? That's the question from Moana. And is this the last we'll hear of it, or are we just setting ourselves up for further problems down the line?
Let me maybe take the second question first, Krina's question, and later on. Is this the last word? Well, we have to believe that's the position of the Supreme Court. So I think it is the last word in that sense. Are we set up for more litigation on this question? I think very much so, because of these complicated exceptions. And it's still there's still a lot of room for arguments for lawyers to say, is there now an express choice of law? Is there an implicit choice of law? Does the validation principle displace the presumption, yes or no? Do we have a similar rule like the rule in Sweden? There is one in Scotland that was also mentioned in the Enka decision. So I think there is a lot of room for litigation. So it is the last word from the Supreme Court, but I don't think it's, I don't think it cuts off maybe even a new stream of cases that will relate to the application of the principle set out in Inca. Now, Krina's question regarding the choice of the seat and whether it will affect the choice of the seat, my gut reaction is no, because parties choose London as a seat for the excellence of the services you get, also in supporting arbitration when it comes to supporting arbitration from the existing courts, from the existing institutions, from the bar and existing solicitors that come with it. So I'm not sure that parties, when making the choice of the seat, go as far as looking at the validity and the proper law of the arbitration agreement for making that. I think they make those decisions on much more mundane grounds, and sometimes even, you know, as we know, at 5 before midnight on maybe wrong grounds, unfortunately.
Thank you. I see we've actually overrun a little. I hope you don't mind. We might extend it a little bit further. There are a couple more questions I thought I might put to you from the list, which I'm afraid we won't be able to cover all the questions, but there are a couple towards the end. There's the question from Natasha Peter and there's the question from Rob Price. The question from Natasha is another question about English law. I'm not sure to what extent the people watching this webinar can actually read these questions, but I'll just read it out. It says, she says that, thank you for an interesting presentation. I was particularly interested that most countries either consider that the governing law is the law of the seat or apply the validation or consent principles. And I wonder what the English courts following Inca would do with an English law contract with a seat in those countries. Logically, they should follow the law of the seat in all those cases. Does that not significantly undermine the simplicity of the Inca approach? So it's to taking the English law question, but putting it into another scenario, another possible scenario.
I do apologize. I was actually looking for the question so I could read it with you. Where was the seat? I missed that.
It's towards the bottom of the list. So if the seat is if the seat is in France or Russia or wherever, but it's an English law contract, and then for whatever reason a question regarding the validity or one of these other issues comes in front of the English courts during the arbitration, say, what will be the approach of English law in that situation? Should they follow the law of France or should they follow the English law approach?
My reading of Enka is to say, as a matter of principle, they will apply English law as the law governing the contract. And it's only if that law invalidates the arbitration agreement, which is unlikely in the case of English law, maybe, then you could go to the law of the seat, France or Russia in your example. Or if in France or in Russia, there is a provision similar to the one in Sweden, Section 48 of the Swedish Arbitration Act, that says if the arbitration is with a seat in Sweden, the arbitration is governed, and therefore the arbitration agreement is governed by Swedish law. As far as I know, there is no so provision in French law, and I I assume there is no supervision, no such provision in Russian law, because otherwise the Supreme Court would have applied that exception in Enka, where Russian law was part of it. But actually, the last point is not entirely correct, because it was the other way around. It was the seat in England and Russian law play.
Yes.
And so I hope that answers Natasha Peter's question. I'm not 100% sure it does, but I unfortunately I can't find it in the chat. So I hope I answered it.
The third from the bottom. Oh no, sorry, there's more. more questions have been added while I was saying that. So it's perhaps somewhere in the middle now.
Unfortunately, I can't see sometimes the names. It just says all panelists and attendees, strange enough. So apologies.
Oh, well, it's in the Q&A box.
Ah, that's why. I'm looking at the chat. Anyway, I hope I did answer it.
Can I take you to Rob Price's question, which is actually a question that's also asked by another attendee, which is the impact of multi-tier dispute resolution clauses and whether that changes the analysis in any way. Does that, and he suggests, does it militate in favor of the lex contractus instead of the law of the seat?
Yeah, I know this debate exists. I have to say, I never really understood why that would be the case. I mean, if you have an arbitration agreement, if that is part of a multi-tiered clause or individually, I would think that the same principles as a matter of concept should apply irrespectively of whether it is the first or the former or the latter, if it's a multi-tiered provision or only an arbitration clause. But I know this has been debated, but I struggle to find good arguments why one should distinguish the solutions for one or the other. But I might stand, maybe change my mind if I hear your arguments. Unfortunately, can't hear them, but.
Yeah. So you'll be happy to end up having different governing laws for different parts of the dispute resolution clause?
I suppose if that is the necessary outcome, yeah, I suppose that might be fine.
We now have 20 questions here, so we're not going to have time to cover everything, but I wonder, I might pick up perhaps if there's a last question.
Can I just say that, of course, as always, I agree with my dear colleague Nusha Basiri that it might be time, as she says, to seriously think about amending Article 2 of the New York Convention, which is about arbitration agreements and therefore include a provision on the applicable law. And yes, that would solve the question even more prominently. But we all know that changing the New York Convention is certainly not a simple thing to do.
Yeah. And perhaps there's a last question from Fabian Gelinas. In some cases, doesn't want how to interpret the clause to determine the law governing its construction. Does that not suggest a transnational approach? So it's, if you like, moving even beyond the validation principle and taking a transnational approach to contractual interpretation.
Yes. So to be honest, when we started this, the second statistics I showed on my slides, and so we said, no, let's have a look at what are the issues actually that trigger the question of the governing law. I was very surprised that the interpretation of the arbitration agreement as a standalone issue was only in 3.5% of the cases. So it only ever comes up in relation to other questions, in relation to the validity of the arbitration agreement, etc. So yes, I would agree with Fabien. but those cases where the interpretation only comes up as a standalone are, at least from this research, which is work in progress, and from that 200 case data set, certainly a very small, the smallest subset of questions when it comes to the law governing the arbitration permit. But it's a great idea.
I agree. And actually, with your mention there of this being a work in progress, perhaps that is a good point to end, in particular by asking you for your plans for this work. Are you, and this has been asked in the chat as well, obviously we promised to make this recorded this speech available, but what are your plans for publishing this research in the future?
I am not sure I'm allowed to say. There is it's actually for one part of the research, and as part of a work in progress, has already been submitted as an article, but it's for a liber amicorum for someone. So I don't want to take the surprise away for that person when that person gets the liber amicorum. So I'm not going to say where it is going to publish, but if you want a copy, do let me know. I'll send you one. And I've also seen that there were some very helpful comments on specific jurisdictions in the chat. So I'll make sure that I'll make a note of this and add it into my research. So thank you for those comments as well.
Well, I think at least people will take comfort from the fact that it will be published somewhere, and they'll have to keep an eye out for it. It's just about 8 o'clock now, so I think I will bring this to an end. Unless there's another question you'd like to pick up, I can see you're looking at the questions. Okay.
I could go on forever, but I'm sure people have other things to do. So I'm in your hands.
Well, as you might see in the chat, there are some very complimentary comments by people. And again, I'm very sorry that we can't do a round of applause at this point. But on behalf of the branch and the CIArb, thank you very much again for your excellent talk, Maxi. And I'm going to bring this evening to an end here. So thank you very much.
Thank you for inviting me. Good evening, everyone.